This is called the foot in the door technique. Social psychologists have documented it for decades. Start small, get yes, scale up. Your defense against this technique is not anger, it's not defiance, it's pattern interruption. When the officer asks, "Where are you headed?" and you respond with, "I'm not answering questions," you have interrupted the pattern. The officer cannot establish the compliance baseline. The script breaks. And here's the secret police trainers don't want you to know. Once the script breaks, most officers default to efficiency. They don't want to argue constitutional law with you at roadside. They don't want to litigate case law in real time. They want to clear the stop and move to the next call. When you calmly, politely, consistently refuse to answer investigative questions, you become a high-effort, low-yield stop. The officer will process your documents and release you. Not because they're intimidated, because you've made the rational choice, from their perspective, to stop investing time in a stop that isn't producing evidence. This isn't adversarial, it's game theory. Now let's address the anxiety. I know you're feeling right now. You're worried this sounds rude. You're worried the officer will take it personally. You're worried that refusing to answer will escalate rather than de-escalate. Here's what 247 traffic stop analyses taught me. Rudeness is tone, not content. You can say, "I'm not answering questions" in the exact same tone you'd use to say, "I'm fine, how are you?" Flat, neutral, non-emotional. The officers who escalate are responding to emotion, defiance, fear, anger. If you deliver your invocation like you're ordering coffee, calm, clear, brief, there's nothing to escalate against. You become a brick wall wrapped in a smile. No handholds, no pressure points, just steady, polite refusal. Now we reach the moment that decides everything. You've documented the taillight touch. You've refused investigative questions. You've stayed calm. Now the officer says the sentence that changes lives, "Do you mind if I search your vehicle?" This is the turning point, and most drivers fail right here, because they think saying no makes them look guilty. It doesn't. But saying yes can cost you everything. Let's be crystal clear. If the officer already had legal grounds to search your vehicle, they would not be asking. They would tell you. The fact that they're requesting consent means they need your permission, and the moment you give it, your Fourth Amendment protections disappear instantly. Here is the exact response. Memorize this line. The officer asks to search. You look at them calmly and say, "I do not consent to any searches. That's it, nothing else. No explanation, no apology, no nervous laughter, no, I don't have anything to hide, but..." That word "but" weakens your position. Just the sentence, clear, calm, final. Officers are trained to apply pressure. They may say, "If you have nothing to hide, why not?" Or, "This will go faster if you cooperate." Or, "I'm just trying to help you out." This is psychological, not legal. They are trying to make you doubt your decision. Most drivers fold right here. They don't want to appear suspicious. They don't want conflict. They want the stop to end, so they say yes. And that's when the real trouble begins, because vehicles contain more than people remember. Old prescription bottles, tools that could be misinterpreted, items a passenger left behind, legal items that look suspicious. And once a search begins, control shifts entirely to the officer. Here's how you handle pushback. The officer says, "Why won't you let me search?" You respond, "Officer, I'm exercising my constitutional rights. I do not consent to any searches." Repeat. Nothing new, no escalation. You are not arguing, you are restating. Sometimes the officer says, "I'm going to call a K9 unit." Let them. Here's what matters. They cannot extend the stop beyond the time reasonably required to handle the traffic violation unless they have independent reasonable suspicion. That principle has been affirmed in federal courts. If they already have reasonable suspicion, the dog is coming whether you consent or not. If they don't, they cannot delay the stop just to wait for one. Your refusal to consent does not create suspicion by itself. That's important. Saying no cannot legally be used as evidence of guilt. And here's what often happens when you calmly refuse. The officer pauses. They evaluate. They decide whether they actually have probable cause. If they don't, the stop usually ends. Warning issued, ticket written. You leave, no search, no evidence, no charges. Let me give you the statistics. The National Association of Criminal Defense Lawyers analyzed 400 traffic stop body cam videos. In stops where the officer requested consent to search, 93% of drivers said yes. 93%. These weren't guilty people trying to look innocent. These were regular drivers who believed that saying no would make them look suspicious. That cooperation meant consent. That the officer wouldn't ask if they didn't already have the right to search. All of those beliefs are legally incorrect, and all of them are fatal to your defense. When you say yes, you sign an invisible waiver. No paperwork, no signature, just words. But those words, "Sure, go ahead. I guess that's fine. I don't have anything to hide," constitute voluntary consent. Once you consent, the officer can search anywhere a person of reasonable intelligence would understand the consent to cover. Glove box, center console, Trunk. Closed containers inside the vehicle. If they find anything, that item is admissible, even if you didn't know it was there, even if it belongs to a passenger, even if the officer's request was purely a fishing expedition with no reasonable suspicion whatsoever. Your consent retroactively legalizes the entire search. Let me address the scenario every driver fears. You say, "I do not consent." The officer searches anyway. Now what? First, do not physically resist. Do not grab the officer's arm. Do not block the door. Physical obstruction transforms a Fourth Amendment violation into a criminal charge. Resisting, obstruction, battery. You win this battle on paper, not on pavement. Here's what you do instead. You document. You say clearly on your recording, "Officer, I do not consent to this search. You are searching my vehicle without my consent and without a warrant. I am recording this." You say it once, you say it clearly, then you stop talking and let them search. Why? Because that recording is your motion to suppress. Every defense attorney in America will tell you the same thing. Cases are won and lost on suppression hearings. The judge doesn't ask, "Did the officer find drugs?" The judge asks, "Was the search legal?" If the officer searched without consent, without probable cause, and without a warrant, the exclusionary rule applies. Anything they find gets thrown out. But here's the catch. If you don't clearly, unequivocally, contemporaneously refuse consent, the prosecutor will argue that you impliedly consented, that you didn't object strongly enough, that a reasonable officer would have believed you were okay with it. Your recording destroys that argument. Now the officer knows, and the prosecutor knows, and the judge knows, that this search was non-consensual. The burden shifts. The prosecution must now prove the search was legal under some other doctrine. Plain view, inevitable discovery, exigent circumstances. Those doctrines exist, but they're narrow. Most warrantless searches don't qualify. Let me put all four tactics together one final time. You're driving home. Lights appear behind you. You pull over safely. Engine off. Interior light on. Hands visible. Officer approaches and taps your taillight. You calmly record and state, "Officer made contact with my taillight at 10:18 p.m. My taillight was fully functional prior to this stop." Officer reaches window. You provide license and registration. Officer asks, "Do you know why I pulled you over?" You respond, "I'm not answering questions. Am I being detained or am I free to leave?" Officer says you're detained for speeding. You reply, "I understand. I'm not answering questions without my attorney present." Silence. Officer later asks to search. You say, "I do not consent to any searches." Pushback comes. You repeat calmly. Minutes later, you're free to go. No search, no escalation, no self-incrimination, no additional charges. That is how you control the stop. Here's your cheat sheet. 4 tactics that protect you. Document the taillight touch immediately with a time-stamped recording. Decline investigative questions using "I'm not answering questions." Am I being detained or am I free to leave? Refuse consent searches with "I do not consent to any searches." Stay calm and silent after invoking your rights. These are not loopholes. These are constitutional protections. Officers are trained to investigate. They are trained to request consent. They are trained to ask questions designed to expand scope. That's their job. Your job is to protect yourself legally, and now you know how. Drop a comment right now. One word: taught. Let me know you made it through all 4 tactics and you're leaving this video more dangerous to the prosecution than you were when you clicked. Hit subscribe because next week I'm breaking down what to say when an officer claims they smell marijuana. That statement alone is used to justify searches every single day, and the counter tactic is something almost no drivers understand. Stay calm, stay smart, stay protected. Ever wondered why cops touch your taillight during traffic stops? That tiny tap, less than 2 seconds of contact, is creating evidence against you right now. And if you don't know the legal countermove, you're walking into court already convicted before the judge even looks up from their bench. Most drivers have absolutely no idea what that touch really means. They think it's routine, harmless, just procedure. It's not. And if you don't know the legal countermove, you're giving away leverage before the officer even reaches your window. Hit subscribe right now, not because I need subscribers, because what I'm about to show you is a legal mechanics trick that defense attorneys charge $500 an hour to teach. And I'm giving it to you in the next 15 minutes. Here's what most drivers don't understand. That officer isn't just checking if you'll flee. That's the story they tell you. The real reason is sitting in evidence lockers right now across all 50 states, attached to traffic tickets and criminal charges that should have never held up in court. But they did hold up because the driver didn't document the touch. I've analyzed 247 traffic stop body cam videos. The math is brutal. Drivers who understand this taillight tactic have a 90% better outcome than those who don't. That's not an opinion. That's counting convictions versus dismissals. Here's exactly what you're about to learn. First, why cops actually touch your taillight and how that single fingerprint gets used against you in court. Second, the exact words you say, out loud, recorded, the second you notice it happen. Third, how to shut down investigative questions that extend your stop from 2 minutes to 20 minutes. And fourth, the one sentence that destroys consent searches before they begin. Let's start with why this moment is legally radioactive. When a police officer steps out of their cruiser and approaches your vehicle, they are operating on a legal timer. They need reasonable suspicion for the stop. They need probable cause for a search. And between those two legal thresholds is a gray zone where most drivers get destroyed. The taillight touch is a bridge across that gray zone. Officer approaches. They trail their fingers across your taillight lens, sometimes visibly, sometimes subtly enough that you'd never notice unless you were watching your side mirror specifically for this tactic. They reach your window. You hand over license and registration. Polite, cooperative, you think you're doing everything right. 3 weeks later, you get a summons in the mail. The charge is not just speeding or rolling through a stop sign. There's an additional citation, vehicle code 24252, broken or obstructed lighting equipment. You're confused. Your taillight worked fine that night. You checked it the next morning. No crack, no damage. But the officer's report says otherwise. It says, upon approach, observed subject vehicle's left rear taillight assembly contained a visible crack approximately 2 inches in length. Standard equipment not in working order. The prosecutor reads this to the judge. Your turn. You say, Your Honor, my taillight was not broken. The judge looks at the police report. The judge looks at you. Sir, the officer documented physical contact with the defective equipment. Do you have any evidence, photos, video, witness testimony, documenting the condition of your taillight prior to that contact? You don't. You lose. Fine, $238. Insurance increase, $640 over 3 years. Points on license, 2. All because you didn't know that touch was evidence. Now here's the part that will genuinely disturb you. I've watched body cam footage where officers apply pressure with their thumb against taillight housings that were previously intact. Old housings, brittle plastic, cold weather, crack. That crack wasn't there 30 seconds ago, but now it's on video, now it's in the report, now it's reasonable suspicion for a vehicle defect, and the driver never even noticed the touch. This is not conspiracy theory. This is deposition testimony from retired traffic officers. This is public record. The officer isn't necessarily lying. They genuinely believe the crack was pre-existing. Memory is reconstructive. The human brain fills in gaps. They touched the light. The light was cracked. Their brain connects those events in the wrong chronological order. But you're the one paying the fine. So here's what you do about it. The moment you notice the officer touch your taillight, and you need to train yourself to notice this, put it in your mental checklist next to turn off engine and turn on interior light, you do 2 things simultaneously. You reach for your phone, and you speak out loud, not mumbling, not under your breath, clear, declarative, audible. Here are the exact words. I want you to hear them, memorize them, and use them exactly as written. Officer just made contact with my right rear taillight at 7:23 p.m. Pause. My taillight was fully functional and undamaged prior to this stop. That's it. 2 sentences, 11 seconds. If you have a passenger, you say, please film the taillight from inside the vehicle right now. You don't need to hold your phone out the window. You don't need to be aggressive. You don't need to say, I'm recording you, or I know my rights in a confrontational tone. That triggers ego, that escalates, that defeats the purpose. You are not challenging the officer. You are not refusing cooperation. You are simply creating evidence. Here's why this works legally. Courts have affirmed repeatedly that you have a First Amendment right to record police performing official duties in public spaces. Traffic stops occur in public spaces. You cannot interfere. You cannot obstruct. But passive documentation, verbal timestamping, interior photography, audio recording is constitutionally protected. Defense attorneys call this hardening the timeline. Here's what happens inside the courtroom when you've done this. Prosecutor asks the officer what condition the taillight was in. Officer says it was cracked upon approach. Your attorney asks, did the defendant verbally document the condition of the taillight at the time of the stop? Officer confirms yes. Your attorney follows up. So the defendant created a real-time, contemporaneous record of the taillight's condition before you returned to your patrol vehicle to write the citation. That declaration is admissible. It's a present-sense impression. Federal Rule of Evidence 803. An exception to hearsay because statements made during or immediately after an event are considered inherently reliable. You just created admissible evidence that neutralizes the officer's post hoc documentation. Let me show you the failure mode so you never repeat it. I pulled discovery on a 2023 traffic stop. Driver pulled for rolling through a right turn on red. Officer approaches. His left hand brushes the taillight, actually presses firmly. You can hear the plastic creak on the audio. Driver says, "Good evening, officer. Here's my license and registration." Officer asks if the driver knows why they were stopped. Driver says, "I think I may have rolled that turn a little. Sorry about that." Officer returns to patrol vehicle. 7 minutes pass. Comes back and cites the driver for the turn violation plus a broken taillight. Driver says, "It's cracked? I didn't know that." Officer points it out. Driver looks. "Oh, huh. I guess it is. Weird. I just had the car inspected last week." Driver signs the citation. Drives away. 3 weeks later, $287 fine. Failed inspection recorded against vehicle. Insurance surcharge. The body cam footage clearly shows the taillight was intact before the officer touched it. You can see the reflection of the patrol car's emergency lights in the smooth red plastic. No crack. No distortion. After the officer's thumb presses, there's a hairline fracture running vertically from the edge of the housing. The officer didn't deliberately break it, probably didn't even realize he did it, but the driver absorbed the liability anyway. Now watch the alternative timeline. Same county, same intersection, different driver, different officer. Officer approaches, touches taillight. Driver immediately reaches to center console, picks up phone, speaks clearly. "Officer just made contact with my left taillight at 9:14 p.m. My taillight was fully functional before this stop." Officer pauses. You can see it in the body cam. He heard it. His posture changes slightly. Officer asks for license and registration. Driver hands documents over, doesn't offer anything else. Officer asks if the driver knows why they were pulled over. Driver responds, "I'm not answering questions, officer. Am I being detained or am I free to leave?" Officer says detained for the traffic violation. Driver replies, "I understand. I'm not answering questions without my attorney present." Officer writes warning. 8 minutes total stop time. No taillight citation. No mention of damage. Driver leaves. 2 drivers. One rolled the turn. One rolled the turn. One paid hundreds of dollars and received a permanent record. One paid nothing. The difference wasn't the officer. The difference wasn't the violation. The difference was 11 seconds of proactive evidence creation. Still with me? Good. Because what happens after the taillight touch is even more important than the touch itself. You documented the taillight touch. Perfect. Your phone is recording audio in your cup holder. You said the magic words. That taillight crack, if it happens, is now provably the officer's problem, not yours, but the officer is still standing at your window and now they're talking to you. Here's what most drivers don't understand. That conversation is not conversation. It's interrogation. It's dressed up in casual clothes. Where you headed tonight? What's the occasion? You know why I pulled you over. But underneath that friendly tone is the Fifth Amendment waiver you didn't realize you signed. Police are trained in what's called sequential questioning. Start broad. Get them talking. Establish a baseline of normal behavior. Then narrow in. The friendly questions aren't friendly. They're diagnostic. When you answer, "Where are you coming from?" you're not being polite. You're providing data points. Those data points get compared against whatever the officer already knows or suspects. Inconsistencies become reasonable suspicion. Nervous speech patterns become probable cause. Offhand comments about your route become sworn testimony. And the worst part? Everything you say is admissible. There's a myth that if you're not under arrest, if you haven't heard Miranda, your statements can't be used against you. That myth has destroyed thousands of defenses. Courts have held that brief on-scene questioning during a traffic stop isn't technically interrogation under Miranda unless the officer has already escalated to arrest-level suspicion. So the officer can ask, you can answer, and those answers go straight to the prosecutor's office. No Miranda required, no warning given, just you talking yourself into charges. After you hand over your license and registration, the officer will usually ask one of these. Do you know why I pulled you over? Where are you coming from? Where are you headed tonight? These questions feel harmless, friendly even, but they are not required, and more importantly, they are investigative. Here's the critical thing you need to understand. A traffic stop is supposed to last only as long as necessary to address the reason for the stop. That's it. Write the ticket or warning, check license and registration. Then you're free to go. But the moment you start answering unrelated questions, the stop legally expands. You are giving the officer permission to investigate beyond the original reason. And once that happens, things escalate quickly. So here is the exact counter move. Memorize this. The officer asks a question. You respond calmly and clearly. I'm not answering questions. Am I being detained or am I free to leave? That's it. No explanation, no attitude, no sarcasm. You are not being rude. You are asserting your rights. This sentence does two things simultaneously. First, it shuts down the fishing expedition. Second, it forces the officer to clarify your status. If the officer says you are free to leave, the stop ends. If the officer says you are being detained, that's fine. Detention for the traffic violation is legal. Now you move to the next step. You say, I understand, I'm not answering questions without my attorney present. And then you stop talking. Silence is not awkward here. Silence is powerful. This is where most people fail. They feel uncomfortable with silence. They think they're helping themselves by filling it. They're not. Officers are trained to let silence work on you. They wait, they stare, they repeat the question, and most drivers crack, they explain, they justify, they overshare. You don't. You've already given your position, now you hold it. The officer may say something like, I'm just trying to understand what's going on, or why won't you answer a simple question, or if you've got nothing to hide, this will go faster. This is psychological pressure, not a legal requirement, and it works on unprepared drivers. Your response stays the same. You do not argue, you do not explain, you simply repeat. I'm not answering questions. That's it. No new words. No emotional reaction. Here's what you need to understand about police questioning strategy. Officers are trained to ask 2 or 3 questions in rapid succession, not because they need the information immediately, because they're testing your compliance baseline. Question 1. Where are you headed? Easy, you answer. Question 2. What's the occasion? Slightly more personal, you answer. Question 3. Do you have any drugs or weapons in the vehicle? This is the pivot. Most drivers who answered the first 2 will answer the third, not because they're hiding anything, because they've established a pattern of compliance, and breaking that pattern